Good afternoon. Welcome again to Florida Appeals Journal. Today, we're going to address declaratory judgments, trying to cover a wide array of topics that hopefully will make your litigation experience more efficient, streamlined, and hopefully more successful in the long run. Declaratory judgments, what is that? We're going to look at explain what it is. When do you use it in litigation? And it's actually a very useful tool to know about when you are attempting to determine and resolve rights that you have under a legal instrument, a written legal instrument, such as a contract, a deed. And this can, if used correctly, has the potential to eliminate the need for extensive and expensive litigation. So let's take a look at it. Declaratory judgments. You're going to be generally looking at sections 86, really chapter 86 of the Florida Declaratory Judgment Act. Under Florida law, declaratory relief, and we're talking about you're asking for a declaration from the trial judge. That is an essential tool to clarify disputes before they escalate into full-fledged conflicts. Okay. The Supreme Court has upheld the fact that parties can seek a judicial declaration when there is a genuine uncertainty about their rights under a contract. And the Higgins case, this is Higgins versus State Farm Fire and Casualty, 894 Southern 2nd 5, Florida 2004. And that gives a really succinct statement on what declaratory relief is. Purpose of a declaratory judgment is to afford relief from insecurity and uncertainty with respect to rights, status, and other equitable or legal relations. All right. So in that case, the Supreme Court held that declaratory judgment actions are permissible for coverage disputes, including the resolution of factual issues. So that's very interesting when you get into like HOA contracts too. But here, this is when it comes to insurance, which of course is a source of all kinds of litigation. But instead of going through expensive traditional litigation, you can bring a complaint for declaratory relief and basically attach your policy and say, we are unsure, we have a genuine dispute about our rights under this policy, trial court. So we want you to resolve that for us. And that can eliminate a lot of a headache on both sides. Okay. So in that case, the court held, quote, we conclude that the declaratory judgment statutes do authorize a declaratory judgment action to decide these issues. And what they're talking about, there are factual disputes, which that is very interesting because you'd think, okay, does that just apply to issues of law? But no, they're saying in that context, it can apply to factual disputes. And the court determined that the Florida's declaratory judgment statutes authorize courts to decide factual disputes in insurance coverage cases, even if it requires establishing whether an event was intentional or accidental. Very interesting. Quote, we believe that declaratory judgments are and can increasingly be a valuable procedure for the resolution of coverage disputes to the benefit of insurers, insureds, and claimants. The Higgins court relied on sections 86.011, print 2, 86.051, 86.071, and 86.101 to support their holding that declaratory judgments are allowed to determine the existence or non-existence of rights, including factual determinations regarding insurance coverage. Okay. And the Supreme Court talked about the policy, of course, which I think we all know I think should be obvious. The court emphasized that by allowing these declaratory judgments in these types of cases, that's going to give clarity to both insureds and insurers, preventing unnecessary litigation and potential bad faith claims. The whole purpose of a declaratory judgment action is to afford two parties the relief from insecurity and uncertainty with respect to the right status and other equitable or legal relationships. Therefore, under that line of thought, the court holds, well, in several cases, that requests for declaratory relief should be liberally construed. So there's no strict construction going on. You want to allow it wherever possible. And that's the Cintron case, 339 Southern 3rd, 459 at 2nd DCA 2022. And I'm just going to quote the basic declaratory judgment provision in the statute. It's 86.021 Florida statutes. Any person claiming to be interested or who may be in doubt about his or her rights under a deed, a will, a contract, or other article, memorandum, or instrument in writing, or whose rights, status, or other equitable or legal relations are affected by a statute or any regulation made under statutory authority or by municipal ordinance, contract, deed, will, franchise, or other article, memorandum, or instrument in writing, may have determined any question of construction or validity arising under such statute, regulation, municipal ordinance, contract, deed, will, franchise, or other article, memorandum, or instrument in writing, or any part thereof, and obtain a declaration of rights, status, or other equitable or legal relations thereunder. So declaratory judgment actions, I believe, are a powerful tool, and when used effectively, can really get you what you are looking for in that situation where you've got confusion over what your rights are. So again, any questions, let us know. Thank you for attending today, and we will see you next time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.